Welcome, everyone. Today I'm going to talk about deepfakes and the law, including the current problems that we are facing and how a federal law could potentially provide a solution. One of the problems of deepfakes is that it can be incredibly harmful in many contexts. A prime example recently was Taylor Swift. Her image was used in deepfake pornography, meaning using artificial intelligence or machine learning algorithms to create synthetic media depictions that show another person doing something that they did not actually do. And here, Taylor Swift's photos were used to create deepfake pornography, and this spread like wildfire on a number of different platforms, including appearing on Twitter for about 17 hours before Twitter finally decided to remove the account of the user that posted the content, saying that this was a terms of use violation. But until that happened, that post had garnered 45 million views. And what Twitter's safety team had to say in response to that was that posting non-consensual nudity images is strictly prohibited on X, and we have a zero-tolerance policy towards such content. Our teams are actively removing all identified images and taking appropriate actions against the accounts responsible for posting them. Now, Twitter did not have a legal obligation to remove that content in all likelihood. Under previously existing right of publicity law, in most states, it is not a violation of the right of publicity, meaning the use of someone's name, image, or likeness, to use their image without their consent if that image is not being used in a commercial fashion or otherwise generating some sort of commercial gain for the person who used it. So in the case of deepfake pornography, oftentimes this content does not result in financial gain for the poster and is simply done to harass or embarrass the victim or to provide gratification for the users. So this is not something that typically falls within existing state right of publicity law, which is focused on the right to prevent your name, image, or likeness from being used in a commercial sense. For example, it's being used in an advertisement or it's being used to endorse a product that you don't endorse. 90 to 95% of online deepfakes are in fact deepfake pornography. This is one of the most common uses of deepfake technology on the internet. Deepfakes also arise to create harms that could potentially violate existing state law. For example, there are posts of internet influencers, especially doctors, who have their likenesses taken and used in advertising, showing them endorsing or using a product that they do not endorse or use. Now, a number of social media influencers like Dr. Yoon have had to combat this with their own posts explaining that they don't endorse those products. But they could theoretically bring a lawsuit under state right of publicity laws if they can find out who to sue. Sometimes that can be a little bit tricky. Sometimes we don't know who's putting up this content and it's difficult to find them. So finding ways to be able to potentially take that content down without a lawsuit can be really beneficial. In another situation, deepfake videos of Elon Musk were used to promise some great investment returns on an investment scam, and this encouraged seniors to spend and lose their savings, their retirement savings, and can cause an incredible amount of harm. It causes harm not only to the people whose images are being used, but also to consumers who fall for those scams as well. Deepfakes also pose risks to corporations. For example, synthetic media can be used to depict a chief financial officer on a Zoom call telling another employee to transfer money to another account. And when it seems so realistic and the voice and the video all seem to match, that makes it more likely that you can infiltrate a corporation and cause the corporation to take actions that they do not want to do. Deepfakes can also result in problems for countries, including by the creation of civil unrest. For example, a depiction of a politician or military personnel engaged in unsavory actions or illegal actions like war crimes could potentially cause immense civil unrest in a country. Right now, deepfake audio, which is a lot better than the deepfake video at this time, is being used in political campaigns to try to impersonate members of the opposite political campaign. For example, a recent situation where a phone call of Biden audio was used to tell people not to vote. So many states have passed laws that specifically address revenge porn, meaning that you're using somebody else's intimate imagery without their consent for the purpose of causing them harm. Oftentimes, this can be solved through copyright because typically those kinds of images are taken by the user who appears in them, such as with selfies. But other times, those images are just taken without permission, or in some cases, they are deepfakes and synthetic media. Only some states bar this conduct. 27 states have laws that protect against AI-generated non-consensual pornography, like the Taylor Swift example. But this isn't something that's available everywhere. This data is from multistate.ai, so thank you for that. One hiccup that tends to happen is that we want platforms to be able to take this content down, like Twitter. We want Twitter to take this content down if it appears on their website. But if their trust and safety teams don't deem that to be a violation of their terms of use or their community guidelines, they don't have any legal obligation to take it down. So for some seedy websites, it might be the case that that content stays up unless there's some sort of legal violation that would actually apply to the host of that content or to the social media platform. Section 230 of the Communications Decency Act provides immunity to platforms that are hosting user-generated content or user-posted content. Now, there are two exceptions that apply to Section 230. The two exceptions that apply to Section 230 are for intellectual property and for child pornography. And as we'll see, many of the laws apply to those types of issues. For example, saying that right of publicity is intellectual property for purposes of Section 230 immunity, or saying that the deepfake pornography constitutes child pornography to the extent that it uses the image of a minor. There is some state legislation. For example, Virginia, here's an example of one of the pieces of state legislation that covers all non-consensual sexually explicit imagery, including deepfake generated content. Virginia was one of the first states to pass a law on this, followed by California. And then we have some states that don't really do that. So Ohio, for example, and many other states don't actually cover the use of deepfake imagery to create non-consensual pornography of a person or to create pornography of a person without their consent. So there is quite a need for federal legislation here. There are two proposals right now that could potentially pass to provide a federal Right of Publicity Act that would extend to deepfake pornography. So one federal proposal is the No Fakes Act. This would provide liability for an unauthorized digital replica of a person. It would hold platforms liable for hosting an unauthorized replica of a person. It does provide some exceptions, and it would preempt state digital replica laws. So it would provide a federal right that makes it so that those state law rights no longer apply anymore, saying that the federal law takes precedence or preempts those state laws. You can take a look at the text of the No Fakes Act. It essentially provides an individual right to ownership over digital replications of your name, image, and likeness. This is particularly important for actors, for example, and this act, this No Fakes Act, could be very useful for actors, especially child actors, because as you can see, it says that we are not allowing assignment of this right, meaning we're not going to allow you to sell the right to create your digital replica, and we are not going to allow minors to transfer that right permanently to somebody else. There's going to be a limit to the amount of time that minors can license their likeness to somebody else to create a digital replica. So this protects minors. It protects actors who have low bargaining power when they're trying to negotiate with studios for use of their digital replica. And then the liability that's available here says that it's a civil law violation to create a digital replica of somebody else without their permission, and it creates a cause of action in federal court under the act. There are exceptions for First Amendment protected speech, for example, use in bona fide news, public affairs, or things that are being used for documentaries or education. There's also another federal proposal that is being pushed by Melania Trump right now that's called the Take It Down Act. This protects against digital forgeries and focuses on intimate imagery, specifically giving enhanced protection towards minors whose images are used in non-consensual deepfake pornography. This provides a notice and takedown provision, which I think is critical for ensuring that right of publicity laws at the federal level are enforceable and are meaningful. If you don't have a requirement that platforms take this content down, it can be incredibly difficult to track down the people posting that content and get them to stop in any reasonable amount of time. 48 hours is a little bit tight and could potentially mean that there's not the opportunity for manual human review of items that are flagged under this law, and that we would have to rely on automated review, which can be problematic and potentially lead to abuse. However, I think that having a notice and takedown provision for deepfake pornography is incredibly important and will save lives. Unfortunately, this is a law that was opposed by the social media companies, specifically by Musk, and has failed to pass at this point, although we will see what happens in the future. I think there's a chance that this eventually makes it through, perhaps with some amendments to help to ensure that there are First Amendment protections in place and perhaps a more lenient notice and takedown procedure. You'll notice that this content focuses on content involving intimate imagery and provides enhanced protection for minors whose images are used to harass or degrade them or to arouse sexual desire in others. So what's going to happen in the future here? There's a lot of open questions, one of which is, are platforms like social media companies going to be liable for the content? Another one is, are we going to have takedown provisions where platforms are required to remove that content within a certain amount of time? Or are we only going to allow for civil liability, meaning a lawsuit is going to be required to take that content down, and you're going to need to get a judge to order a preliminary injunction to take that content down fast? That can potentially pose huge harms if you need to wait 30 days or 60 days or years to be able to get that content removed from the internet, and that might be irreparable to your emotional safety. And then we also have the big question of, do we want federal right of publicity laws that extend to deepfakes? Do we want a federal right of publicity law that covers all right of publicity so that we have consistent laws between every state in the United States? Personally, I think we need a federal right of publicity law, not one that just applies to deepfakes or to non-consensual pornography, but those are critical first steps. And I do think that a notice and takedown procedure is going to be incredibly valuable for any law that prohibits deepfake pornography. Thanks. Let's see what happens.